Hello. Yes, it's me, Dr. Michael Arnheim here again. This is the third in the series Know Your Rights, and this one is called The Snail in the Bottle. I hope you enjoy this series and benefit from it. It is intended for anybody who is interested in their rights or in any aspect of the law. It doesn't matter whether you've had any legal education or training of any kind or not. Makes no difference. So why the snail in the bottle? Snail in the bottle is about a case that was decided by the House of Lords, at that time the highest court in the land, in 1932. You might think, well, what could that possibly have to do with me? Well, the answer is actually quite a lot, because that case represents a break with hundreds of years of principled law, and it marks the end of principle in this branch of the law, the branch called tort of negligence, T-O-R-T, tort of negligence, but also actually more generally. And as we'll see in a later talk, law without principle produces injustice. You cannot really have law without principle. But that is what we have in this country, I'm afraid. So, what happened in 1932? Mrs. Donahue, May Donahue, went to Mingella's Cafe in Paisley in Scotland, and there she ordered a ginger beer float, which is ginger beer poured over some ice cream in a tumbler. And the proprietor opened the ginger beer bottle, which is sealed up, and he poured a little of the liquid into the tumbler, which already contained the ice cream. And Mrs. Donahue took a sip of that, and then her friend, who actually was paying for the drink, her friend was treating her, poured some more into the glass, and that's when a semi-decomposed snail floated into view. Semi-decomposed snail. And Mrs. Donahue had not developed a taste for snail-flavored ginger beer, which I understand is now all the rage. But she certainly didn't have that taste. On the contrary, she got, so she claimed, violently ill with gastroenteritis as a result of the very little that she'd had, or I think more from the sight of the semi-decomposed snail. And now the question was, what remedy did she have in law? Did she have a legal remedy? Well, actually, she didn't. But she won the case. How did she manage that? Well, the thing is, she didn't have a normal remedy in a case like this. There are plenty of cases of people getting sick in restaurants and suing the restaurant. But to do that, you've got to have a contract with the restaurant. And then you sue the restaurant for breach of contract. But she couldn't do that because she didn't have a contract with the restaurant, because she hadn't bought the drink herself. She was given it. It was a treat paid for by her friend. So couldn't her friend have sued in contract? Well, her friend could have, but for what? Her friend didn't suffer any ill. Her friend couldn't claim there was a breach of contract with her. So she couldn't claim. She had legal status, but she didn't have any basis on which to make out a claim. Whereas Mrs. Donahue did not have a legal basis, but she had a factual basis, so she claimed. So what did she do? Well, her lawyers decided they couldn't sue in contract. There was obviously no breach of contract here, and she didn't have a contract with anybody. So they sued in tort, T-O-R-T, which means a wrong. It's French from Latin, meaning twisted, meaning wrong, a civil wrong, and this is the tort of negligence. So, but who was negligent? Was Minghella negligent? No. The proprietor of the cafe? No, he wasn't, because those ginger beer bottles were opaque. You couldn't see in. And in fact, they were even referred to as stone bottles in those days, stone, because you just couldn't see what was inside. And they were sealed up. So anything in that bottle was there before Minghella opened the bottle. So he was completely off the hook. But she sued the manufacturer of the ginger beer, Stevenson, claiming that he was negligent because during the manufacturing process, somehow or other, a snail had got into that bottle. Now, she lost in Scotland first, as indeed she should have done, because the law was actually very clear. The law was that a manufacturer was only liable in law in the case of an article which was dangerous in itself, which obviously ginger beer is not. Or, where the article is not dangerous in itself, then it was dangerous due to some fault or other which was known, it had to be known to the manufacturer. So either it was an article, had to be an article dangerous in itself, or one which was dangerous for some other reason and known to the manufacturer. Well, that wasn't the case here either. So clearly, Mrs. Donahue actually should have lost the case. How did she manage to win? Well, largely through the efforts of Lord Atkin. He was a maverick Australian Welshman, and he managed to carry with him, to some extent at any rate, sufficiently to win the case. He managed to carry with him two Scottish judges who were sitting on this case, because it was a Scottish case after all. So, but it was a case which was decided under English law, because they decided that English law and Scottish law, Scots law, were the same in this area. So that's what happened. Lord Atkin won the case for Mrs. Donahue on the basis of what he called the neighbour principle. Now, there was no such principle. He made it up. It's not a principle at all. He said, love your neighbour as yourself, and in law that becomes this vague principle, which he called the neighbour principle, that whatever you do, if it affects someone else, you are liable. It's so broad, it's not a principle at all. And the two senior English judges sitting on this case completely rejected it, pointing out that you can't just make up the law. The common law is what we're talking about here. The common law of England, the common law, cannot just be changed by judges. The only body that can change the law is Parliament. Judges cannot change the law, and that is what Lord Atkin was doing, changing the law, making it up. Why? Well, I suppose because he felt sympathy with Mrs. Donahue. Yes, we can feel sympathy for her. She had presumably suffered illness, gastroenteritis, from this little incident. We can sympathize with that, but that doesn't give her a legal right. and certainly does not give any judge the right to change the law, which is what happened here. And Lord Buckmaster, who was a former Lord Chancellor, made it quite clear that the law, the common law, cannot be changed by a judge. Similarly, Lord Tomlin, the other senior English judge sitting on the case, actually used the word illegitimate. He said, "There is, in my opinion, no material from which it is legitimate for this court to deduce this so-called principle of the neighbour principle, which is so vague. It's not a principle at all. Not a principle at all." And that's why this case is so important, because it marks the end of principle in law, which had been dominant for hundreds of years. The law in this area, which is tort of negligence, has been, since that time, for the past 90 years, has been, as even some senior judges now admit, in disarray, and lacking reliable principle. Now, once you're in that position, that means you cannot predict the outcome of a case, and how can you have justice in those circumstances? And that is, unfortunately, the position English law is in now, not only in the tort of negligence, or tort generally, but across the board, pretty well right across the board. We'll say more about that later. That's why this case affects you, because it meant the end of principle and the beginning of disarray in English law. Very, very sad, very, very sad case in that respect. More next time. Thank you.